to the okay. Grandfather tells. An old grandfather, well, I'm going to back up for a second. I know many of you have heard this story. I always like hearing it again. I hope you do too. An old grandfather said to his grandson, who came to him with anger at a friend who had done him an injustice, "Let me tell you a story. I too at times have felt a great hate for those who have taken so much, with no sorrow for what they do. But hate wears you down and does not hurt your enemy. It's like taking poison and wishing your enemy would die. I have struggled with these feelings many times." He continued, "It's as if there are two wolves inside me. One is good and does no harm. He lives in harmony with all around him and does not take offense when no offense is intended. He will only fight when it is right to do so and in the right way. But the other wolf, he is full of anger. The littlest thing will set him into a fit of temper. He fights everyone, all the time, for no reason. He cannot think because his anger and hate are so great. It is helpless anger, for his anger will change nothing. Sometimes it is hard to live with these two wolves inside of me, for both of them try to dominate my spirit." The boy looked intently into his grandfather's eyes and asked, "Which wolf wins, grandfather?" The grandfather smiled and quietly said, "The one I feed." So you can figure out why we started with that one. And we're really welcoming you here and hope that I believe we'll learn as much from each other as from anything Sandra, or at least that I say. And we're simply going to start off with reality testing. Why do it? So you're there. Parties have said their spiel. At what point? We'll deal with that later. But why? What's the purpose of reality testing? And I'm going to remind everyone that when you've come into the room, you've been muted automatically. So you can just jump in, or we'll call on you if it gets too rowdy. But why do you think we reality test? One more thing I'll say before we start is Sandra's going to be capturing these in notes. We decided not to use a screen share document because this way we can see all of you and try to track who's wanting to interact. And we know that some of you would prefer to have a visual too. We've just decided this is the way we're going to do it. And we will be sending at the very end a list of notes and some questions that we've come up with. So who would like to offer their idea first? Why do reality testing in a small claims mediation?
It helps the party focus on what they want. What is their best outcome? What is their worst outcome? Why are they there? I think a lot of times people are wrapped in emotion and they have a problem actually focusing on what is it that they want.
So why are they there? You're helping them focus. What is their best outcome, their worst outcome? Their emotions been just like a blanket around them, and you're helping them figure out what's best for them. Awesome. Sahar.
It's a good opportunity for the parties to test their preponderance of evidence, that how strong their evidence is look like in the court in front of the judge.
So it's a good opportunity to help them reality test the evidence they have and how that might show up in court. Okay, great. Mike, you moved, but I saw you before.
I don't know if this is going to make sense, but it's almost like reflecting back what they say, in that it's giving them a greater view of their feelings and how they're approaching the issue that's in front of them.
Okay, so reflecting back what they say helps them have a bigger view of what their position is and what they're saying and what's in front of them. Great. Who else? I'm seeing other people joining us. I'll just say hi while one of you's thinking of some more. Brenna, hi. Patrick, hi. Sahar already said hi. Mike, hi. I think I had said hi to everyone. And Glenn. Who else? Who's next? Why reality test?
I can say something. Another thought that I had was it helps, I think, make sure that the resulting agreement, if there is one, is more likely to be followed. If you reality test well with both parties and they're thinking everything through, they're more likely to have a better agreement that's going to cover all possibilities.
Great. So reality testing them may make the agreement actually more rich and resonant and durable. And because they've gone through all the possibilities. I have to tell you, Nicole, I had never thought of that one. So awesome. Who else?
I think it also it is an opportunity to paint a picture of what might happen if they do go to trial, so that they have clear pictures in their head about the two paths they might take.
Yeah, so it's an opportunity to give them, like, here's the video of what might happen if you do go to trial. Here's one path, here's the other. Yeah. Anybody else?
We had a situation the other day in a mediation where there was reality testing for one of the participants where they wouldn't accept the offer that was in front of them. And so the reality test was to just point out and state the obvious about how much they're risking with regard to their decision to proceed the trial.
Yeah, so an opportunity when there is an offer to help them examine the risk if they decide not to accept it and go to trial. Cool. Anyone else? Going once, going twice. Okay, so Sandra and I thought that we would talk a little bit about each of us about why we think there should be reality testing, adding on to all of the wonderful ideas and maybe repeating a few of them that you've all brought. And the reason for doing this, I think, is part of the beauty of you being a facilitator in this conversation. I've often thought, oh, this super famous person has said this and already taught this to us. Why do 50 other people, what's the point of them saying it? Well, the point is they may say it slightly differently so it resonates with one of the 50 billion people that they're trying to reach. And I think reality testing can be like that. So, but some parameters about why you've talked about it, helping them figure out their best decision. People come into mediation, in my mind, they have their blinders on. They're convinced, I'm going to win. I wouldn't have brought this suit if I didn't think I was going to win. I've been feeding my view of this for the entire life of this incident in my life. So I look at our job as to try and help them take the blinders off, or at least open them up a little bit more. Why? So that if they end up going to court, well, first is to help them make their best decision. And I don't think they can do that if they don't think about what all the ramifications are of this best case scenario and this worst case scenario and everything in between. So that's a big part of the why. A second part of the why for me is it just pains me to think somebody's going to end up in court and feel blindsided. Like, I never thought of that. I can't believe the judge is ruling against me. Or I can't believe that I didn't think of this. It's not even necessarily about the ruling, but the ramifications of saying X in court. We'll come back to that later with an example. So we have that opportunity to sort of get them to flex their thinking a little bit. And we can do that in a variety of ways. We'll come back to that later. But what is one of the reasons that we don't want? We're not trying to reality test to push an agreement. I really want to take that off of everybody's goal sheet. And I am very realistic. We need to get agreements in small claims to have this program continue. But that is not our real goal. Our real goal is to help these people have a discussion that gets them to think it all the way through. And if they end up going to court, they have a better way to present their side to the judge and allow the judge to decide. And we can do that by helping them look at what their evidence is, as I think Nicole said, somebody said, Sahar said. And the ways, and we can have the judge be this background figure throughout the proceeding that doesn't need to come front and center until maybe you do need to. But in my mind, the judge is always in that background. And I'm thinking about it, about how's a judge going to look at this if they do end up in court? And we may never even need to get to that. By reality testing, you may be able to keep the focus with the parties. We're not trying to push our own agenda. Self-determination is still one of the glowing goals out there. And then we'll do a little bit more. I think the rest of my thoughts are about some hows, or some of my thoughts. Yeah, and the sort of idea that everybody comes in with expectations, and can we understand what those are and help them adjust their expectations to a potential reality? I mean, the truth is, we don't know what the reality would be in court. And yet we do know some of the things that a judge might be wondering about. Sandra, you want to give your thoughts about why the reality test, or any other thoughts you want to share?
Sure. First off, great to see everyone. It's just really nice to see all of you. And I think a lot of what I would say has already been covered. I think the biggest thing for me with reality testing is helping folks to make their own best decision, supporting their self-determination. And so under that umbrella of helping them to support their self-determination, are talking through what the risks might be, asking them what the risks they see, potential risks might be. Sometimes they come in there and they say, well, so-and-so told me that the law says this, or so, and they're putting the weight of their case on what someone told them and kind of talking that through with them. And then their evidence. So talking it, just reflecting back. So it sounds like the evidence that you have is this, this, and this. And how do you think the judge might see that? And so the other party, this might be in private meeting and talking that through, and then, talking through. So in joint session, the other party said they had this evidence. How do you think the evidence they have might impact the evidence you have? So just helping them to think through that piece. Sometimes there are other folks who are not in the room with them, and there's the weight that they carry on their shoulders of what they're going to tell their friend or their spouse about the case, versus that person's not there. And so just kind of having the conversation with them around what's really going to be most helpful for them. Thinking about how has this case been impacting you up until today? And if you don't reach a decision today, what's it going to be like when you go home tonight? You know, and how's that going to feel to still have the weight of the case, you know, knowing that now you're headed towards trial? How would that be for you? So just really helping them to think about all of the possibilities.
Yay, thank you. So does, I think those are some of the highlights of why. Where we were thinking about going next is how. And so I'm not sure if we, I'm just gonna go ahead, if it's okay with you, Sandra, and say some of the ways I think about the how. I'm not into the specifics. We're gonna ask you, and I think I asked you in the email, to come up with some examples that you'd like some practice reality testing, because so many of you have these beautiful languages that I would like to get to the point where I can type them out and email them to everybody post debrief. But some of the ways of reality testing to distinguish that reality testing versus pushing. I'm not pushing somebody to make an agreement. I'm not pushing them to take my view of this case and do what I think they should, even though I'm trying to hide it. Because remember, we're doing facilitative mediation. We're not doing evaluative or directive. And so asking what kinds of questions? Sandra's fantastic at this.
Open-ended.
Yay! Yeah. So there's one of the hows. And one of the things that I've talked about in debrief, because we've been talking a lot about reality testing lately, is when one does it, you might, it's often, sometimes you can do it in joint session and it feels perfectly appropriate. Sometimes it's better to do it in private meetings, because then person doesn't have that desire to save face and to hide their real agenda. They've, at least if you've established sufficient rapport, and reminding them that it's confidential and that kind of thing. So when I do that in a private meeting, and I think when lots of you do it, can be really important to remind them that you're doing this for both sides so that they don't feel pushed. You can say, you know, part of my role here is to play devil's advocate with you. Could I do that for you? It's just so that you can have a better way to think about your own case and what decision you want to make. It may help with some people to ask that permission. And I really want to assure you that I'm going to do the same thing with the other side. I don't want you to feel pushed. And then guess what? Sometimes I do push. I push pretty hard on some thing that I've heard already that I think they're not thinking rationally, or they're doing something that I may be aware of a law that they're going to come up against. Now, I can't tell them the law, I can't give them legal advice, but I can try to expand their thinking about that. And I can push pretty hard, and then I back off. So what about if this happens? And what about if that happens? And da 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 da. And you do not have to come to an agreement here. You do not have to decide. You have the ability to take this to the judge. And then maybe a next part of it, and we can do this a little, is like, and what if you do go to the judge? How are you going to feel? We'll hit that a little bit later. So those sort of concepts of testing versus pushing, but pushing and pulling off, not pushing to an agreement, but pushing them to think. And how to do that, to really give them the freedom to first set it up by saying, I'm doing this with both sides. This is just part of my role. I don't actually know what your best decision is here. If I were in your shoes, this would help me figure it out. I'm going to do this with the other party too. There may be some evidence you haven't thought about that our discussion will bring out for you. And then just playing with that again, often for me, and some people don't need to go to private meeting. They're able to handle it in joint meeting. I tend to be an introvert and a little bit more private with what I'm willing to disclose. You guys wouldn't know it because you're a part of my intimate family. But anyway, that's just some of the ways that I think about it. How about you, Sandra? How to reality test?
So let me just recap some of what I've heard. So open-ended questions, kind of bringing up those what ifs so they can think about them and answer their own question around those. Pushing parties to think, not pushing to agreement. And then transparency around what you're doing with the reality testing, letting them know that you're helping them to think and that you will be doing it with both parties.
Yeah.
I think you pretty much covered it, Kathy.
Well, I'm sure that some of our other brilliant folks have something to add.
Mm-hmm.
This is just the part of how to reality test. Then we'll do some specifics. Mike.
There we go. So a question, what if one of the parties, you can tell that whatever they're seeking, they're just way off base? Okay, I mean, it's just obvious. And not so much the other party. The other party's got their stuff in a row and are doing fine. How do you approach that? And you get them in private conference. How do you approach that reality testing when you're really not going to reality test with the other party?
So,
because it's very comfortable to say, I'm going to do this with both parties, but in some cases, you're not. Or
well,
if
I
you
might
are,
still
it's
have
really
a
superficial.
Yes, and that I think we all experience. But I'm still going to tell them that my general path is to reality test with both parties. And the reason for that is to try and get them to feel less defensive and open their mind. And the how of, there's a point, Andy's on this call. He had a debrief last week, and I don't even know if it was his case, but he reflected back to me something I had said, and it's kind of stuck with me, is I might try with that specific person who has their view feels very out there and very unlikely that they're going to get what they want. So I'm thinking, I don't want them to be blindsided. I want to help them take their blinders off. I want to help them make their best decision. Part of how, so I think we're sort of easing into the specifics of doing it. In that case, I actually might, I'd ask them some openness, how likely do you think, when I hear what you say about this and I hear the other party say that, so that's one of the things of the hows that I didn't write down, is really using the specifics that you've been given from both parties. Really keep those in mind, not just general questions, but go to the specifics and hold them up in front of them as a mirror. So when a judge hears you say, Mike, you haven't given me enough specifics to work with, blah, 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 and Joe, your opponent, has said, wah, 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 what do you think a judge is going to do with those two? And this is the part I'm coming back to what I was referring to about Andy, is I may actually put them out into the future about So what if a judge doesn't agree with you? And a judge decides, rules against you, and you now have, this is a part of the specifics I do want to come back to. You have a judgment against you, you have to pay prevailing party fees, you have to pay the other side's court costs, and you've lost your position. How is that going to feel? I actually will launch them into the future and allow them to touch into feeling the pain of losing their case. Remember, isn't that what we were talking about, Andy?
Feel the pain, Kathy, to drag their face right across that agreement. All up in that lawsuit, just scrape it like a grater.
That's right. Andy was saying, so you really want them to put them into that pain feeling. But it is a part of reality testing to me. I want them to understand what their possible outcomes are. And I want to come back with more specifics to those three things I talked about: the judgment, the prevailing party fee, and the court costs in a moment. But does that answer at all, Mike, what you were asking? Okay. How about somebody else? Want to give Mike a way you would approach what he talked about? A party that's their request, their belief is way outside of what you as a mediator think is realistic, and up against another party that seems to have their ducks in a row.
I'll just add one thing to what Kathy said as well. So the piece around what Mike was talking about was the scenario of reality testing, where you're reality testing with one and maybe the reality testing with the other looks very different. And that can be the scenario with a lot of cases. So yeah, just knowing that can be the case. And then kind of the reality testing where you as the mediator are seeing, and again, like Kathy said, we don't have the actual scenario. Just thinking about, though, if something seems really off, or like what they are expecting seems far-fetched, I'm checking myself too. So at the same time that maybe it's triggering something in my mind, I'm also checking me, and is this possibly, are they possibly right? Could this possibly happen? So that I'm being cautious that, am I still being neutral here? Am I, at the same time that I'm going to help reality test it? So just some other things to think about.
Chuck. We're not hearing sound, but I don't see you muted.
How about that? Is that better?
Yeah. Better.
I'd like to stick with Mike's concern about symmetry. I think we often end up with asymmetric situations where you're in a private meeting with one party, and I mean, it's just a cat fight and it's really complicated, and the other one is, I don't know what, the other one is a collection agency. And you really don't have much to do with them. So I think this is the reason that rewinding way back, I'm interested in this question of reality testing in joint versus in private meetings. I don't think I've ever tried any really thoughtful reality testing in joint. That seems like that's a private meeting project for me, because then I can really work with whatever that party has brought. That's just an observation. One other observation from before. In part of my opening briefing, I always make a big point about how the judges are unpredictable. And by setting that up at the get-go, then I can drag that back in when I'm doing reality testing, saying, I can say things like, wow, that kind of makes sense to me, but I'm not sure it would make sense to a judge, because they come up with whatever they come up with. So it sort of opens by putting it there, then you've got it to bring back later. I'm getting ahead a little of what you're doing, but observations.
So I hear that for you, doing it in private gives you more freedom to push people farther and ask them questions. And at the same time, I'm in a reality test, not really reality test. So I understand the desire to go on to somebody's side to get that rapport going. And when you said, well, that makes sense to me, is it okay with you, Chuck, and everybody, that we each sort of push back on each other? Okay, so when you say it makes sense to me, it triggers an alarm bell that for two reasons. One, it feels like I'm stepping out of neutral territory. And two, I think that person will then they'll hear that. They may not hear the next part. So it's just a way of, I understand that desire to get the rapport and feel like they're safe enough to listen. And I caution about that kind of language. So one of the other things that came to mind from some of this is this idea that about getting trapped in a party's story or their perspective. And I'm seeing, this has happened on a number of occasions lately, but we had a debrief, and some of you may have been on it, with Sephora, where I think it can happen to all of us. And I love Sandra's reminder that we need to check ourselves. Am I just buying into this because of who I am and my life experience, and I'm not remaining neutral and taking my own blinders off? I can give you, this isn't a case that happened, but I imagined when Sandra said that, if there was a case between neighbors about cutting down trees, I'm going to be on the save the tree side. And I really need to check myself to not get trapped in the tree savers story. Or sometimes, and if we do, then how do we bring ourselves back out of it to really reality test both sides, the side that we believe and the other side. It's easy to test the other side if we have this internal belief in one side's story. But it's really important to notice, oh, wait, I am starting to think this person's story is just out to lunch and this other person's reasonable. And so actually, to a small degree, Mike, it's hard to find you guys when the pictures change. I do feel like I need to still test the other side's story, to reality test them both to some degree. And I'm finding myself right now thinking this is kind of general talk, and I'm not sure that it's landing in specific ways. So I'm going to propose to Sandra, well, I'll pause first and see if anybody else has comments they want to make at this point. Okay, then I'm going to propose to Sandra that we go to specific of the prevailing party fee, a judgment and stuff, and then we break out into specific cases and questions you have, scenarios that we can play with. Because there's an edge for the reality testing that we don't want to cross over into giving legal advice or any advice. And so some people are afraid to reality test because they're concerned. I've heard this articulated in the debriefs that they are trying to push somebody and they don't feel like that's fair. So we want to be aware of that line, but don't stop ourselves from reality testing them, because that does a disservice to them. So this is a piece that I've been really playing with people in debrief, is the end of a case. So imagine that people are deciding they want to go to court. And let's play with the version where it's a large amount that's at stake in there. somebody's asking $5,000 or $10,000. And they've decided there's either no offer or an offer that's not acceptable to them, and they're willing to risk it in court. And it may be, again, this may be the first part of reality testing that ends up with them. So is it worth raising to them the fact that they might end up having a judgment against them? We no longer, at least I no longer know what the negative impact of having a judgment is, but I know it is still negative. We used to be able to bring in, this is going to impact your credit. We can't say that for sure anymore because the credit reporting agencies changed the way that they report things. But so the judgment, the prevailing party fee, I just want to clarify for people. My memory of the statutory language is that the prevailing party fee is a shall for the judges. However, they don't treat it as a shall. They treat it as they have discretion. And remember, there is no appeal. So basically, they get to do what they want with it. The reality appears to be, from the number of cases that I've looked at over the years, is that they generally do award the prevailing party fee to whoever prevails in the case. And I say prevails as opposed to wins. So I'm a plaintiff. I bring a case against a defendant. There is no counterclaim. The judge says, you didn't meet your statutory requirement of preponderance of the evidence. You know, I could see your point by about 40%, but not 51 or 50 point something. Therefore, I'm going to rule against you. When I rule against you, I'm going to say the other party gets the court costs. What are the court costs? It's I should have looked this up, but I think it's $57 if it's $2,500 and under. And if it's over, it's $102. Take that with a grain of salt. But the other court costs are the service fees, if there have been any. Service fees vary. The sheriff's service fee is $45. People can use private service companies to serve. And this morning, I actually listened in the background to a case, and I heard for the first time a judge who's been with us for about 2 years now, so she has some experience, say that they are holding the service fee to $45. I don't know if I haven't been able to check that out. Are all of them doing that? Because in a case 2 years ago, we used to have a frequent filer use their own company to do service fees. And one time they asked for $800 in service fees. The court denied that, but they were initially routinely awarding $170. So I don't know what the court ruling is, but service fees are part of what that, and then the prevailing party fee, which is now $135. So I'm the plaintiff. I'm merely filing this case, absolutely sure I'm going to win. And you've tried to reality test me on the evidence and that, my mind went blank, the burden of proof, the preponderance of the evidence. You've tried to say, well, how does your evidence stack up to what the other person's telling us and showing us? But I'm still convinced. Okay, so I'm going to put you forward to the day of trial. The judge finds that you didn't meet your burden of proof. And I'm sorry, I'm very distracted by something happening out there. So the judge is going to tell you, sorry, I'm not ruling in your favor. I'm ruling against you. What happens then is the judge may award the prevailing party fee, the court costs, and to the other party. you have a judgment against you? Have you explored what the negative impact on your personal reputation or your company's reputation is going to be from that? There's a question you can use in reality testing. How will that impact your business going forward?
Kathy, I have
Also,
a quick question. In terms of the award, is the judge actually going to say, sorry, you don't reach this? Or is it just going to be pretty pro forma? You lose, you win, here are the costs. Do they give them any kind of analysis?
totally depends on the judge. Some of them do, many of them don't. They say, I've listened to the evidence, here's my ruling. But so as you remind them this is where you have that opportunity to put them into the feeling, not just keeping it at the facts of, okay, now you have a judgment against you. Is that the feeling could go into the impact, but I really might invite them to feel the pain, Andy, rub their face in that pain. Again, I'm going to push and I'm going to pull back. I don't want them to make a decision because of that, but I want them to have considered it. And I want you all as mediators to keep that in mind, to let them know that that's one of the things they need to be thinking about. Now let's go from a $5,000 case to a case where the person's asking for $150. We have those. We have one coming up next week or the following week. Or cases where there's less, it doesn't have to be 150, it can be 800. But somebody's very convinced they're going to win. They never even have considered that they might have to pay this other person up to $200 or $300. I want them to not be blindsided at that point. So that's part of why I'm going into this in so much depth, because in debrief, I've heard a number of times where that hasn't occurred to the mediator to talk about with the other party. And I think it's really important to do so. Because even if it's in your PowerPoint, if you use that, or it's in your opening remarks, I know they don't hear half of that. That's why we're doing reality testing, because we've talked about this before, but I know it doesn't land until it suddenly lands. So that feeling of, so what will it be like if at the end of the day, you actually have to go home and, as Sandra said, tell your people, I lost and I have to pay them $200 or $300. Sometimes, I don't know if it add up to 300. I guess it could easily. 135 for the prevailing party, 45. I don't think all the judges are holding that to 45, but maybe they have a new rule. I think it would be brilliant if they do. So that's what, 170? Did I do the wrong math? And then if it's another 102 for the filing fee, we're up to almost $300. Not only did I not win, I have to pay that horrible person that my wolf fed me all these thoughts about, and I let that wolf win. So that's part of the reality testing that I think is really more important at the end of a case when they're going to trial, just to prep them. So I'm going to pause here and see what your thoughts are. If there's anything anyone wants to add, take away. Remember, I am always super open to being pushed back against, because I learned from that too. And I know I'm wrong a lot of the time.
I've had a couple of cases recently where one of the parties was really standing on principle and wanted a forum to express or explain the injustice that that they were subject to. And I think in both the cases I'm thinking about, I think you know, they had pretty, during reality testing, they had a pretty good idea of that they might not win, but they really wanted that public forum. Any thoughts on what to do in those situations? Or, you know, if we, yeah, what's our due diligence in those?
My immediate response is let them have it. But first make sure they understand and let them play with the idea that if they lose, how are they? I'm so convinced I'm going to win. It's the principle of the thing. And what if, in fact, the judge says, no, you lose? How is that principle? How are we going to feel about that? That's one of the cases where I would take them out to that feeling part of actually losing. And at the same time, I'm going to back off because they do have the right. And some people clearly state, I don't care, it's worth it to me. Great, let them go. What do some other people have? Because many of you have probably encountered that situation, or you will, because some of you are newer. Thanks, Kathy. Glenn.
Well, I've had my career was in dealing with grievances that were filed by union members, and many cases, you know, they just felt very righteous about some kind of discipline that they wanted to go get it tested or you know, to overturn it. And I've had situations where agency heads in state government would, you know, push back tremendously against me to try and get a settlement. I would have a settlement for them, and this person they fired would not come back. But that wasn't enough for the agency head. They wanted they really wanted to have their day in court, and it wasn't just enough for them to make sure the person wasn't going to come back under the provisions I negotiated or a lesser discipline. Let's say it's that I negotiated a lesser discipline. Well, it practically killed the agency head to come to that agreement. But the point was using the Batna Watna kind of ideas of saying, well, what happens if they lose and they come back? And their response, shockingly sometimes, was, well, I'd rather have the judge make me take the person back than do it myself voluntarily. I'll look weak.
You know what? They have the right to do that. That's what, remember we said one of the shining things is self-determination. So I'm not going to try and disabuse them of that. I'm simply going to have them think out what are the other consequences. You know, in that case, I'd say, so looking weak, how's that going to impact future situations with other employees who come in? Have you thought about that? As long as you have, that's fine. It's good with me.
That's right. That's what I always felt my job was, just to try and make sure they understood, okay, here's what happens if you lose. Here's what happens if you win. Here's how the labor relations will be impacted if you lose. So
I appreciate that you have that sort of skill set and that history. And slightly different way to adjust it here is I'm not going to tell them. I'm going to ask them to think about it. And that's a significant difference that I do here in debrief that I want us all to remember. We're not going to tell them, if you lose, this is what's going to happen. We're going to ask them. So what if the judge doesn't agree with you? How will that impact you, your reputation, your feelings, blah, blah, blah. I was going to say, I don't want to keep repeating myself, but I do, because I think it sometimes takes that to soak in. Nicole.
Yeah, I was just going to say one other thing I noticed in like mediations that I've observed so far. I saw at least one where in reality testing, the party insisted that they were going to win and didn't even want to entertain the notion of that they would lose. So the mediator kept asking, I understand that you feel confident that you're going to win. That's great, but do want to talk through all the options with you. You know, what might it look like if you don't win? And they were just like, I don't need to think about that. It doesn't matter. and like not wanting to be too pushy, or maybe there were better questions that could have been asked to get through that kind of hard wall. So yeah, I was just kind of curious what your thoughts were on that, or tools that might be successful in trying to get through that wall of the person not even entertaining that as a possibility.
So something just comes to mind, and that is to use humor. Okay, I get you're so convinced you're going to win that you don't want to have this conversation. But you know what? I have to do this. It's part of my job. Would you just bear with me while I go through this? Because my coordinator is going to really ream me if I don't. Or another way is to make up a story, to tell about a case where you had heard that, yeah, that was what, and here's what ended up happening. Again, knowing, at least I'm thinking, the odds are they're still not going to hear me, but I'm going to do what I can to try. And they get self-determination. How about others? Suzanne, you have. And then Victoria.
Well, I just have a question about that, making up a story. So you're saying that it's okay to say, look, I just mediated a case where X, Y, and Z, and this is what happened. So is that what you're saying? Like you can actually say, like, it was similar to your case? That to me sounds like I'm.
No, that's not what I think.
Okay.
I think when I said make up a story, it was actually, it may not be appropriate here. You may not be able to do it fast enough. I would be like the grandfather of the two wolves, some kind of story that gets them to think a little differently.
It's like an analogy, you mean?
Yeah. And it's, again, not to try to persuade them. And one might not come to mind.
Can I jump to this story thing? Because this is of special interest to me. Suzanne, one of the things that I have often said to
Chuck, can I pause you for a second?
Sure.
So notice that's one of my favorite mediation techniques. And the reason I really want you to hold on to that, Chuck, but I noticed that Victoria had asked to speak first. So I want to go there and then come back. Will that work for you? Thank you.
Thank you. Well, I just had a question about how it works in Multnomah. So I can remember several cases, but one in particular where the plaintiff really felt like she wanted to prevent other people from having the same experience that she did. And so she had this idea that, if she won, then somehow that news would spread. I don't know exactly what her thinking was. But in Clark County, I don't think that would work. I don't, even if I think it was a landlord tenant case. So I'm just curious about what the experience is and how ideas about reality testing that for a party.
So are you asking about reality testing when someone thinks this is going to help others, and somehow the way it's going to help others is others are going to hear about this and they won't be subjected to the same egregious behavior?
Right. Mm-hmm. That they're doing it for the sake of the community.
So, I'll just go into saying, so I would validate their positive intent there, but then ask, well, really, how do you think this, play with them. How is this going to be, others going to hear about this? These aren't reported cases. And just play with their thinking. How realistic is it? And is it that important to you? Because we did have a case somewhere recently where a party agreed to pay, let's say defendant agreed to pay plaintiff X number of dollars to let go of their claim. And it may have been landlord tenant. I honestly don't remember the things. And it was the first case I've seen in 6 years where the party's principal And the idea of helping others was so important to her that she was willing to sacrifice her own financial interests to get this in front of a judge and hopefully make a record for others. So I just test out how important is it to you, how realistic is what you're hoping is going to happen. Does that answer you at all?
Yeah, and I am just wondering about the reality of it. Does it get reported for other tenants who are looking? I mean, I don't know actually if that shows up.
So if there's a judgment against somebody, it's a public record. And if I have landlord A, and landlord A has been sued 10 times, and there's 10 judgments against landlord A, I can look that up.
The tenant could, yeah.
Yes.
So
And then tenant could post on Yelp.
Yeah.
You know, how is it going to get out there? I don't know. It's not, the court's not going to publish anything beyond. Very rarely, somebody asked, Glenn asks, very rarely a judge will articulate in the judgment their reasoning. It's so rare. I think I've seen it happen 3 times in 6 years. But even then, it's not going to make the newspapers, and somebody's going to have to find that case and read that.
Mm-hmm.
So yeah, that's something that's helpful for you all to know. How do things get reported?
Thank you.
Yeah. So Chuck, I'm sorry I took you, you know how I love your stories, so please
Well,
come back.
I just, and to add something on Victoria's concern, I think we hear this a lot. You know, I'm going to make an example of that guy. I think that can be reality tested too, exactly Kathy's point. How is it that people, so let's go down the path that you do go to trial and the judge rules in your favor. How will that information then change the behavior of the other party, or how will that be published? So you're inviting them to describe to you how this, I mean, they may not even be able to, which may be helpful as a reality testing device. What I wanted to jump in on was Suzanne's idea of, well, are we going to make up stories? One of the riffs that I have used often to try to suggest the openness of mediation is that I will say something to the effect of, you know, in mediation, we can cover all kinds of things. And here I'm now entering into a story. A couple of weeks ago, I worked on a landlord-tenant case, and wow, they worked out the money really quickly, and we wrote that down, but then they wanted to include something about a dog. Judges don't do dogs, but we can do a dog in mediation. That's baloney. I've never worked a landlord-tenant case that involved a dog, but it's a way to sort of get them thinking bigger than it's not just the money that we're here to work on, because sometimes the dog, the metaphorical dog, may actually unlock the money.
So I love even the language and the thing about what we have so much more flexibility and creativity in mediation to reach issues. And just for those of you who are new, judges can do dogs, but it's very unsuccessful often. Like I observed a case where it was excruciatingly painful case. A woman who had been married to a couple's son, and the woman and the son got the dog together, and the son died, and temporarily the dog was living with the couple. And so the wife and the couple are fighting over the dog now. I think they came to an agreement. I don't remember if it was an agreement or a trial, but let's just pretend it was a trial. Judge orders that couple return the dog. The couple don't fulfill it. What's the remedy? The judge is not going to have the sheriffs go and retrieve the dog. They're going to give a dollar amount. So one of the judges actually talked to me, not about that case, but we were just talking in general. And he said, whenever he gets a dog case like that, the remedy for him is if they don't comply, they're going to pay $10,000, because then typically they will comply. And which is actually an interesting idea to keep in mind, that you reality test, is the remedy sufficient to help the parties comply with what they're agreeing to do? So does anybody else have any things now, other, or Sandra? Otherwise we can do a break and come back.
I'll just add one more thing then before we go to break. So circling back to the question around ways to reality test when one of the parties is just sure that they're going to win. And so kind of what Kathy talked about, so kind of reality testing that. And so, you know, reflecting back for them, you know, like, you know, so this has been going on a long time. It's costing you this much money. You're feeling like this is very unfair. It's been stressful. And you seem, you know, absolutely sure. And so what's gotten you to the point where you feel that sure? Because your case is now riding on that sure that you have. And so peeling that back and helping them to think through, how did they get to the point where they're absolutely sure? And then the what if. So as sure as you are, with all, as long as this case has been going on, it's felt so unfair to you. You talked about, you know, nights where you can't sleep because this is weighing on you. And what if your worst case scenario, that the judge, you know, that you lose the case and the judge potentially awards, you know, what was talked about in the opening remarks, that prevailing party fee, those court fees. So what if on top of all the fairness, what if on top of how long this has been going on, the judge were to then have you pay those costs? Then how would that be for you if that worst case scenario were to happen? So really putting them in the place of what if all those things, even as sure as they seem to be.
Thank you. So this had an idea come about attorneys when you asked about how did you get to this point. So when we come back, somebody remind, and we'll reality test how to deal with somebody saying, well, my attorney said this. So how about you have an assignment during the break, come up with Kathy's closing story, or, because she doesn't have one, or come up with a couple of scenarios that you'd personally like to hear others talk about how they would reality test. And I have some examples I can do at the end or at the beginning. But this is the part where in some of these trainings, you would go to your obligatory breakout room. We're not doing that because I've been stuck in breakout rooms that did not break out into fun. And we think we can learn with this number of people here more effectively. So it's 2:35, 2:45. We'll see you again. Thank you, guys.
Thank you. And also, Kathy, you asked me to remind you to start off with when parties say my attorney said.
We can start there. Okay. Anybody have a response that they would like to share? So I'm party A and I'm like, well, my attorney said this is it. This is what the judge is going to rule. We even have some attorneys on here that could help us, but it looked like you wanted to say something, Chuck.
I was just going to say, is your attorney an attorney or a judge?
I think that's a fun kind of answer in a way. So Any other responses? Amy, and then Mike.
Yeah, being a retired attorney. So you can always say that, well, as we all know, judges can be wrong. So
Yes.
that's why they have appeals. So
But not here in small claims. They don't have appeals.
I know, exactly. But I'm just saying the point is, though, that just because your attorney says it, it kind of getting back to Chuck's comment, that just, you know, because you don't want to belittle the attorney. That makes the life a little bit complicated. Although I have seen times when I thought the attorney was wrong. But anyway, yeah, just remind him that the judge is the one that makes the decision. So.
That's right. And so one other, there's two things that come to my mind in this. And one is to go back to that idea of being trapped into their way of thinking. Because I have heard mediators go, well, their attorney told them this, and they don't reality test that. Rudy has a way that he will, it's not necessarily that somebody pitches an attorney, but I think it might apply there, is I'm thinking about, well, I get, and your attorney could be 100% right. And what if the judge doesn't believe your attorney? I mean, we have attorneys that are coming with in court. There's 2 attorneys or more. So there's a way of reality testing. You've seen TV shows where 2 attorneys are arguing the same fact pattern, but they come up with different opinions about it. So is that something that, but I have seen mediators get trapped. Well, they said their attorney said this, there's nothing to argue against. Again, I was thinking when I was getting something to drink that for me, it's actually, I don't know that I can come up with as many sort of rules about it as the actual fact pattern. And I kind of like to play devil's advocate with everything. So take that on and just first you test it in your own mind. And then you can bring it to life in that particular situation. So, Amy.
So the other possibility, depending obviously on the situation, is that maybe some new facts came out during the mediation that the one party was not aware of, and so obviously the attorney wouldn't be aware of it. So that's, I mean, that again, that depends on the circumstances.
Yeah, but that's a beautiful reality test. You know, has your attorney heard everything that was said today? Was there some new information for you that maybe the attorney would need to consider? And looking towards the future, it's possible, maybe even likely, that we're going to have a lot of landlord-tenant cases as the rent moratorium expires. And there's likely going to be attorneys telling clients which way they will, what the reality is. And yet the reality is these judges haven't seen this law applied yet. So, and that was what I was going to bring in, Rudy's rule of 10. I can't articulate it nearly as well as he does. I sent it out at one point. So any of you new people, I sent it out in a newsletter probably a few years ago. But any of you that want it, remind me and I'll find it and send it to you. But it's something like, well, have you ever thought about if you pitch this to 10 different judges, how likely is it that they're all going to come out on this side? Or even pitched it to the same judge 10 different days. So just to get them to remember, oh, people are not always consistent. So any more attorney? Come on, anybody got a good attorney joke? Come on, Patrick. Okay. So let's move on then, unless somebody has something more about attorneys. Mike, did I see your hand?
That's okay.
All right. How about some specific cases that you guys would like to talk about? Mike, now I
Yeah.
see your hand.
Because that's where I was going to go. I was going to ask if you wanted a specific case, but you brought that up. And it doesn't include an attorney. So I had a case, and it was fairly complex. Plaintiff had purchased a home with an as-is contract and had an independent inspector look at the home and was claiming damages. And the case drug on I continued it once or twice to try to reach an agreement, but once to try to reach an agreement. There was a cultural issue. The case involved an interpreter who did a great job. There was a cultural issue where the plaintiff, in dealing with the issue, used language that any of us in a disagreement would use, but had grossly insulted the other party because of their culture. So that was overlaying the whole thing. And so the plaintiff had purchased this home with as this contract, had their own independent inspector look at the home, and then was coming back claiming that there were undiscovered damages. And I tried to reality check her everywhere I could over probably 4 to 6 hours of mediation. And I think part of the issue was she was a relatively young person, and she was a relatively young person, and her parents were influencing, I'm pretty positive, were influencing her decision to take this to court. But I tried reality testing every way I could with her to make her understand that with an as-is contract and and her own independent inspector, a judge would probably not view her case in the most positive light. And I couldn't get anywhere with it. So any help with that one? But and with the cultural context, and it's a culture that I do have specific information about and specific dealings with. I was pretty sure that because of the level of insult, that the defendant wasn't going to really budge because they felt that their honor had been abused. And so help me with that one.
I'm going to first ask Sandra to do her most magnificent, one of the many magnificent things she does is, can you reflect back what you heard the scenario to be? So those of us who might have.
So it sounds like it was a case around somebody purchasing a home. They bought the home as is, and they had an inspection as well. I'm hearing there was a cultural piece. So one of the parties said something that in that other person's culture is an insult. And I'm also hearing that the person who purchased the home as is and had the inspection done has their parents may be kind of in the background and in their head and weighing in on the case in that way.
Yep.
Okay.
That'll do it.
And so what I'm also hearing, fantastic, I love to listen to Sandra reflect back. I do. Is, so how do you help this young purchaser with the as-is agreement and the parents in the background? Can you help her expand her thinking to, this is an as-is purchase? Is that what you're asking, Mike, that you thought she needed to get that through a little more, or?
Yeah, that, yes. I mean, there's the whole other issue on how do you deal with that person and try to help them understand that different cultures interpret language in different ways, but I don't know if this is the forum for that.
Well, I think that's a beautiful question, because you're trying to help a conversation between two and somebody that may not have the understanding that their language is impacting the other party. So, I mean, that's a question about, I'll just say it because I'll forget it if I don't, and I really want to hear from other people. So how do you think the way that you're asking or talking to these people is impacting them? Are you noticing body language if they're on video? Or is there a way that you might say that they might be able to hear it more effectively? So those are some of the kinds of frames when I think there's a cultural piece that's at odds. But the specifics of, you've got an as is, there's lots of other examples you might bring to them. Go ahead, Chuck.
I was going to say, one of the things that I've often resorted to when you've got handshake agreements that have gone south, I will say, well, boy, you know, the judges really like paper. And so they listen to everything, but it seems that they always are going to end up looking at the paper. So help me understand what you have in paper. That would be maybe a way to deal with this question of, it's, you know, lead the party back to telling you that it was an as-is agreement.
So again, I love the intent there. Sandra, can I let you pipe in?
I was just gonna say, so when you, is this something, let me just ask first, did both parties agree this was an as-is?
Yeah.
Oh, yes.
Huh.
Yeah, so,
Yes.
so I'm hearing that you both, that's something you agree on. This was as is, and then to each party. So what does as is mean to you? And to the other party, what does as is mean to you? And just kind of starting from there.
And what do you think the judge is going to interpret as is?
Absolutely.
But I love the first, well, what does that mean to you? Particularly to the young woman. So again, this is challenging to me, and yet this is what we do, right? So Chuck, I love again your intent. I do not want us telling parties what judges do, because in Oregon, things don't have to be in writing. Verbal contracts to some degree are okay. And I don't know the law, but I've heard judges say that. And so I think that our misperception that things have to be in writing can lead them astray. And so I just want to clarify that, particularly for newer people. But I like the clarity. You know, how do you think that, you know, the idea of having paper, did you guys put this on paper? Is there clarity? What did you expect? What did you expect? That piece.
Can I ask a question really fast, just on the what Sandra mentioned? Is that a safe question? You know, what does as is mean to you, and to ask until you've established rapport, or before you've established rapport? Because that seems to me to be, I mean, if you haven't built the rapport, I wonder if people might take that to be an aggressive question. I'm just wondering about thoughts.
Kathy wants to respond. The other Kathy, let's get her voice in here.
Other Kathy. I hear what you're saying, Patrick, but I often will have that sort of situation and premise it by saying, oh, it sounds like you guys agree on the facts, but not the interpretation of the facts. So what did you have in mind when you said blah, blah, and what did you? Yeah.
That's a nice way of turning that. Thank you.
And Patrick, I really appreciate you bringing that up, because when I first asked people in some debriefs why they hesitated to reality check, or was because of their fear that it might be interpreted in a way that's pushing them or felt aggressive. Personally, I believe you established rapport in your opening statements with them. And I look to Sandra, I also look to Sephora for the ability to ask anything with rapport and voice tone. And in fact, Sandra and I had a little, I've already forgotten what it was, but how we were gonna, it's a specific case I was gonna possibly talk about if you guys didn't have enough examples. And how I would ask that question in debrief with a tone of voice and the snarkiness that I would never put into a mediation. So if you're just asking the exact words you said before, Patrick, with genuine curiosity and kindness, I don't think they're going to take it that way. And maybe you even preface it and say, I don't want this to sound like I'm trying to interrogate you at all. I'm just trying to help you think through your situation. So you sort of, there's a concept I learned somewhere, communications course, that sometimes we're trying to talk to another person and it's like we're dialing their number and we give the 7 digits, but we forgot to put in the area code. Mm-hmm. So it doesn't get there. So our area code is to say, I just want to help you think this through, rather than just what that means to you. There's a different tone an attorney is going to use in court versus what a mediator is going to use here.
Yeah. Thank you all. I appreciate it.
I'll just add in there, Patrick, I really appreciate that question because like Kathy said, it is so important that as you are kind of doing your opening statement, giving those opening remarks, kind of you're building the rapport, and as the parties are giving their snapshots, and you're creating the safety by giving them the space, by reflecting back, you're building up to being able to kind of ask these questions. And then again, so important, the tone, how you frame them, your body language, everything, just really thinking about and being mindful of everything about your person as yourself as you're asking those questions. So thank you.
No, I appreciate that. Thank you. It's a good reminder that you build rapport from the get-go and build confidence from the parties from the get-go.
Yeah. Yeah. So Mike, did that help you at all with your question?
Yes. Yeah, yes. I'll leave it at that. There are 2 or 3 thoughts that are going through my head right now.
Well, and I tag on the things we talked about, the what is as is, I love Kathy's, sounds like you both agree on the facts, but your interpretation of the facts is different. So what does as is mean to you? What does as is mean to you? What do you think the judge is going to do? But also to take that younger party to what if the judge finds against you? What's that going to, here are some of the consequences, the prevailing party fee, the judgment, the court costs, and your feeling at the end of the day. Go ahead.
So let me take that, what you just said, one step further. And what is the difference between and I know there are several differences, but what is the difference between reality testing and coaching?
I'm not sure for me that it matters, but so
And is it appropriate as a mediator to be a coach when you're dealing with someone where you have a special area of expertise and they do not, and to try to help them understand whatever that issue might be?
So off the top of my head, and I'll let Sandra chime in or anybody else, I think coaching is absolutely appropriate in some circumstances. Keeping in mind, we're not giving them advice, we're helping them think through their situation. I'm not going to give them a mini lecture series on this particular culture's way of interpreting language. But I will ask those broader questions. How do you think the way you're saying this is landing on them? Are which is harder to do online. In the room, they're going to feel it and see it more. So I'm going to have those broad coaching questions. In my mind, that's coaching. And I'm going to do the push pull and they may not want it. It's their mediation. I'm hands off if they give me a clear signal that that's not welcome. So I don't know that I will make a distinction between coaching and reality testing in there. Still, my goal is what are my goals? To help them make their best decision, to not have them blindsided, and not to push them to agreement, but allow them to do self-determination. Sandra, did you want to take this?
Oh, I think you said it well, Kathy. So the piece around you're asking the questions, and like Chuck with they kind of mesh together. Chuck's thank you. Chuck's visual of the coaching and the reality testing, and thinking about, I guess I'm curious in this culture piece, when this happened, when whatever was said that was insulting to one culture, did that happen in the joint session?
Actually, it did not. It happened before they came into mediation.
And how did you become aware of it?
When the party that was insulted said, and I'll paraphrase because I don't remember the conversation exactly. She called us liars.
Mm.
And in that particular culture, from that particular plaintiff, okay, given that she was young, they were older, she was young, and she was a woman, that was a gross insult.
And did that come out? Did she say that in joint session? Did she?
No, the plaintiff did not say it in joint session. It had been said before they came into mediation.
Yes, so I'm hearing it was said before mediation. I'm hearing you became aware of it in mediation. The plaintiff told you in mediation. I'm wondering, did the plaintiff tell you in the joint session of mediation that this had occurred, or did the plaintiff tell you in a private meeting that this had occurred?
Oh, Sandra, if I remember correctly, private meeting.
Okay. And so
because if it had happened in joint session, I would have felt comfortable taking it a little bit further, or maybe a fair amount further. But
good.
So I'm pretty confident it was private session.
Good. I see Kathy about to.
Well, I don't want to take over. I want you to pursue but I do have an idea, and it's not a specific idea.
So great that you would then feel comfortable to help them to have that conversation if they were in joint. And so how do you then explore it in private meeting while still maintaining the confidentiality? And so what do folks think?
Turn it around and ask the insulted person how they think it might help their discussion if the other party understood the insult, or if they shared the insult.
Yes. Yeah.
So, and the part that I just want to underscore here is when we have a fear of, we have an intuition that going down that direction that you brought up first, Mike, and you just articulated a path to do it, Kathy. But if we have that intuition that something might be useful here, but we're a little bit afraid to do it for whatever reason, it's in private meeting, we don't know. I encourage us to take a pause in our own brains and almost do the reality test with ourselves about what's the impact of not going down that path? What's the impact of going down that path? And then how can I do it? Because sometimes I think we have that intuition, we think we have to know exactly how right away, and we don't. Or we have that intuition and it's a little scary, so we just back off. And so that's kind of almost the deeper message to me about reality testing. Go with what comes up for us and push into it a little bit. And then, it may not be appropriate to, but that's my pulling back. Push in, maybe not. Sometimes not.
Yes. And so Kathy's question, Kathy Pickett, a beautiful question to ask the person in private meeting, and then checking in if they maybe don't want to share, then reality testing, how is that going to impact, the ability to reach an agreement with this person if you have this hanging over your head, that this is just keeps going back and forth through your mind, and helping them to think through that. Any other thoughts on the court?
Or I'm also noticing our time we have about 15 minutes left. Any other other scenarios you want to play with? Kathy.
So I am often stymied by how to reality test when it's basically a he said, she said. In terms of evidence or what they're going to present to the judge. So I'd love to get some thoughts on how to get them to hear what they're saying and think of how someone else might interpret it.
I'm going to do a Sandra on you here. So I've heard you say, get them to hear what they've said. How do you do that?
Well, reflect back.
Yeah, and reflect back. How did they hear the other person? And then simply ask, how do you think this is? I mean, that's part of it for me. And then I think you have an ability to bring in the issue of credibility, because you're talking, it sounds like a scenario where there is no other evidence. It's simply he said, she said. And you can bring in the burden of proof. So when a judge hears that, do you think one of you is going to meet that burden of proof? And is there a credibility issue? Why would the judge be more persuaded by yours than the other? I don't know. Anybody else?
On that point, I mean, I would ask them, okay, if you want the judge to believe you, you have to show the judge that what they're saying is not accurate. So other than what you're saying, how are you going to demonstrate that? Because I think Kathy is right, bringing in the burden of proof issue, especially for the plaintiff side. I think that, the plaintiff has the obligation to show that what they're saying is accurate. So, if it's a he said, she said, and the judge, is going to shrug their shoulders and, maybe pick a side. So I think kind of inviting them to share more information about what they want to present to the court might be helpful, because it may show them that they don't have any other information to present to the court.
Yeah, and then taking them out again to that ending step. How will they feel if if the judge rules against them and they have these consequences, and what's it going to feel like? Is it worth going forward? So that's another question, is just a standard not tailored to any specific case. Given everything you've heard today, is several questions came to mind. Of course, one of them just left. Is this worth going forward? Having heard everything you've heard today, is there something that would, is there a number that would make it worth your while to end this today? Might not be your perfect number. And I think all of you guys have actually more practice with those questions than I do. So I'm going to invite everybody at the end of this today, or whenever is convenient, but preferably today, to send in any questions that have come to you or that you use in a standard thing, and I'll type them up and send them out to everybody at the end. So is that help, Kathy, or not?
Yes, it does. Thank you.
Okay. So we have time for another one or two maybe, or I can also, if you don't have any, I have two examples. I'm happy to. Anybody have a particular one they want? Okay, then. Or Sandra, maybe you even have one. I forgot to ask you. Okay, so these, I should have been recording more of these over the weeks, but two of them stuck with me. And they both may be familiar to different people in this room. So there was a case where I'm trying to not give you all the details because they're really not important in terms of the reality testing aspect, but a house sale and a homeowner was very assertive, and in the sale of the house, a defect became apparent, pretty big defect. And the purchaser got a home inspector involved, and I think they bowed out of the sale. The homeowner is suing them to recover for the earnest money, I think. These details are less important, but the homeowner asserts that it's going to be a he said, she said. And the homeowner says that the buyer's inspector is just a home inspector. They don't have any, they say there was a defect. I say there wasn't. And the homeowner wasn't going to cost nearly what the inspector said it would cost to fix. So I may be butchering this a little, Patrick, but you'll get the point. And you can chime in.
I think you've explained it pretty well.
Okay. And this homeowner is absolutely asserting that he's gonna be the one that wins because the inspector has no credibility in terms of knowing what they're doing. They aren't the ones that fix the repairs, and the judge is going to accept the homeowner's assertion So that's why it's like in the homeowner's mind said, it's a he said, she said. So just how would you reality test that homeowner? Super dominant, super, I'm going to win, da, 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 da. Amy, I see some lights going off.
Well, actually, it's going back to my experience. Usually, a home inspection clause is in the contract, and if it says subject to a home inspection, then that's usually.
But let's imagine that's not part of the scenario.
Yeah. But it's there. I mean, it seems to me there must be some way in which the buyer can say, based on, I mean, because there is going to be some sort of writing with a home purchase, and it's got to be somewhere in there, one way or the other.
Well, let's get away.
Sorry, this is where probably my background is not helpful.
But the issue is the credibility of the inspection, right? In other words, I'm saying, hey, I know more about this than some lousy inspector. Is that right?
Yes.
That's the issue.
Yes.
But yeah.
And so a mediator, I can imagine in my younger days, I might have been intimidated by this person and just the force of their certainty.
Yeah, but
I'm no longer intimidated by them. And when I hear that, I'm like, really? You think a judge is going to give you, who's asserting the claim, more credibility than an inspector who makes their livelihood doing this?
Yeah.
Well, and
Now,
they're licensed and bonded and everything else. They pass exams.
right. But I want you to notice, did you hear my voice tone?
Yes.
That is not how you would, except occasionally, I think it's appropriate. Because it might take that level of matching to get somebody in that position to really pay attention. But I would not go there first. Sandra, how would you phrase that question? This was our joke about Kathy's snarkiness and Sandra's wonderful way of approaching things.
Well, so I'm just hearing about the other part. She gave me a little snippet about the case, and I'm just hearing that the other party was a really strong personality type of person. So I'm thinking that the reflecting back for the person with the strong personality is going to be extra important. And so, saying how this is your home, you've lived here for however long, you feel very sure that you know all about this house, and going to trial. If you don't reach agreement and you do go to trial, it sounds like it's going to be your word, the homeowner, against the home inspector. And so, what do you know about home inspectors? What kind of training do they go through? How do they get to be a home inspector? And just kind of asking those questions around that, and then starting to ask those questions. So how do you think the judge might, what kind of weight do you think the judge might give you as the homeowner? And what kind of weight do you think the judge might give somebody who's an inspector who, from what you're understanding, they go through training. From your understanding, they have to get a license. So how do you think the judge might weigh that?
Thank you. Thank you. So one more. A case where a party brings the suit against a company where there was a written contract that plaintiff was going to do work for company, but plaintiff worded the contract that plaintiff would be paid $0. Both parties knew that that $0 was fictitious, and they both had a common agreement that the $0 would be, let's just say $10,000. I don't know what it was. And then company does not pay. So Plaintiff is bringing lawsuit to recover $10,000 with a contract that says zero. Plaintiff discloses in mediation, both parties are aware of this, and this is why they wrote the contract this way, that plaintiff did it because plaintiff was collecting unemployment and did not want to lose unemployment benefits because plaintiff was earning money. Love Patrick. Look at Patrick, who's a lawyer, putting his head down and going. And there were issues on the company side about some significance to them if they didn't settle. That we won't go there because I don't remember what they were, and those were reality tested. But to me, the first thing that came to mind was what I'm guessing came to Patrick's mind is, I'm going to let Sandra reword this. Seriously? You're willing to go in front of a judge in a court of law and tell them you are trying to defraud the unemployment insurance, and you're expecting the judge to award something in your favor? Oh, and by the way, you work for a public university. Do you think there could be any consequences? I don't know whether your university requires it, but there's ethical concerns that they can terminate you for. You're kind of a young dude. Is this really worth risking $10,000? Anyway, so now Sandra, I love this playing with Sandra, because I learn from Sandra every time I'm with her, and I love it.
Well, thank you. I appreciate that. And I'm wanting to give other folks an opportunity to try out how you might reality test this.
This is part of what I love about her.
Well, I think that what I would do is almost ask the same questions that Kathy asked, but in a different tone. Because that just, it's the crux of the issue for me. How do you get around the fact that you're asking the judge to essentially endorse your fraud? It just boggles my mind. But anyway, I think that the only thing that I would change is the tone, and I wouldn't put my head in my hands.
So how might you formulate a question around that, Patrick?
I think so. What I'm hearing is that you both put in a $0 amount for the work in the contract because you didn't want there to be any record that you were receiving money that would impact your unemployment. Is that right? And so you're going to tell the judge that's why you were putting this contract together with a zero amount? And how do you think the judge is going to take that? Just curious. Yes. Something along those lines, I suppose. Yes. Maybe that wasn't, a great tone, but.
Great. Anyone else? Any other thoughts on that?
I might also say if you're not going to disclose the unemployment angle, then what sort of argument are you going to give the judge for why you should be paid when you both signed this contract?
Yes.
Don't you love small claims?
And one other question, how might you reality test with the other party who also entered into this agreement, who also knew about the $0 and the expectation of the other party being paid, and why?
Similar questions, right?
Yes.
Are you willing to have your reputation impacted if this gets out? Yeah.
Yeah.
Well, folks, this brings us to time, actually a moment over, but I really appreciate playing with this with you guys. I think it's just a really interesting part of what we do. And the last thing, I'm going to go ahead and I'm going to, my computer shut down. I have to go through all that password stuff to get it open again. One of the things I do think sometimes that I haven't used as often as I might, and maybe it's inappropriate, is to take people above the level they're at. Like there was a case where people were so about the principle of the thing and just not moving. And so one of the questions can be, so is there another principle you have that's even more important to you? Or, so when you look at this whole conflict, how much importance do you want to give it in your life? What might it be worth it today to get this settled and put behind you? So because I just have to, I'm going to read it again. It's a different version. An old Cherokee is teaching his grandson about life. A fight is going on inside me, he said to the boy. It is a terrible fight, and it is between two wolves. One is evil. He is anger, envy, sorrow, regret, greed, arrogance, self-pity, guilt, resentment, inferiority, lies, false pride, superiority, and ego. The other is good. He is joy, peace, love, hope, serenity, humility, kindness, benevolence, empathy, generosity, truth, compassion, and faith. The same fight is going on inside you and inside every other person too. The grandson thought about it for a minute and then asked his grandfather, which wolf will win? The old Cherokee replied simply, the one you feed. Thanks, guys. Lovely to hang out with you. Send in the questions that you use or that you heard today so that we get a good record to send out to everybody else. Please.
Everyone.
Bye.
Thanks. Bye. You want to stay on, Sandra?
Nice
All right,
job.
I'm going to pause I'm going to stop the recording so we can send it out.